Pleading. We all know Washington is a notice pleading state, and notice pleading certainly applies when pleading real property type actions. Some of the case law here indicates, however, that it's going to be best to plead ejectment and quiet title together, even if there's a question as to whether or not they both apply, because I think my case down here at the bottom, yeah, Byrd versus Pierce County, it's a 2018 division, I believe it's a Division II case. That court declined to allow a plaintiff to proceed on quiet title because it hadn't been pled. Just so sort of despite the fact that these doctrines very much overlap, and despite the fact that amendments to a complaint should be liberally allowed and should be allowed to conform a complaint to the evidence, Byrd versus Pierce County warns us to make sure that we properly plead these, because you might be in a use it or lose it situation. Again, I don't know that that would be the universal rule, but it certainly is good advice to somebody who's going to go out and plead one of these cases. Going back to what they told us in law school, you know, join everybody and plead all your theories at once so that you don't get left holding the bag later. Another aspect that sort of came up through a number of different cases that I reviewed is that there's a certain amount of flexibility in what you need to prove in order to establish superior title. There's not a direct A, B, get you to C. Pointing to Finch v. Matthews here, 74, Washington 2nd, 161. That case contained a lot of discussion about how title that the plaintiff was seeking to defend was obtained by equitable estoppel. It wasn't a prior conveyance, and that wasn't required in order for the court to quiet title in his favor. So there is a number of different ways to get to the finish line. And in preparation for filing one of these cases, I think that would be something that an attorney would really need to spend some time thinking about is, how do I establish title? Is it straightforward? Do I have a conveyance? Or is there some other theory, whether, some estoppel theory, adverse possession, something else out there? And how am I going to prove that? And can I prove that? Okay, getting directly into pleading, I have provided here an example of a case that I filed in Pierce County Superior Court. Looks like this was in 2021. This particular case, based on the nature of it, I pled just two causes of action, ejectment and unjust enrichment. The background on this case was my client purchased the property at a sheriff's sale. The deed of trust had been foreclosed, and the prior owner, who's the prior obligor under a defaulted promissory note, stayed, wouldn't leave. Throughout the period where this ejectment was going on, this particular defendant had numerous appeals going, numerous superior court cases. He was litigating the foreclosure and challenging the order on summary judgment that had been granted in favor of his lender. So there was a lot of different balls in the air at this time in this particular case. Ultimately, none of those appeals or any of the other actions that this particular defendant had engaged in really ever went anywhere. But he was certainly trying to muddy the waters. And ultimately, you will see in this case, I guess he got too busy messing around with all this other stuff, and he just forgot to file an answer. And so we were able to default him. I suspect that defaults are not uncommon in this setting. I think it was addressed in the earlier discussions and earlier comments. And certainly, if one is seeking to regain possession of property, a default and a default judgment is going to be the quickest and most desired result. Otherwise, as we talked before, I mean, this sort of a case just tracks on a typical civil track, which means, let's just call it a year from filing to that date that you get in front of your judge or jury on ejectment. Now, of course, that summary judgment would always be available in the interim, and that may speed that timetable up. But there's going to be cases out there where summary judgment may not fly. There may be material issues of fact that would preclude summary judgment in favor of a plaintiff and the issuance of a judgment and a writ. So that's something that a client would really need to understand about this sort of action. Is very different in this regard from unlawful detainer from that time perspective. At least as to getting a writ of restitution, a unlawful detainer action moves pretty quick. Although I think we talked earlier that in King County, they don't move as quickly as landlords would like them to. But nonetheless, compared to a civil lawsuit that may ultimately be tried to a judge or jury, they are very quick. And a client who comes in and says, hey, I need to do an ejectment really does need to know that they could be in this for the long haul. Another very well, before we go on, does anyone have any questions about pleading, the complaint, seeking a default, anything along those lines? All right. A, a really interesting component of this was trying to get a writ issued from the clerk's office. Now, again, this kind of all goes back to when we talk about writs or we talk about restitution, we talk about removing someone from a property, everyone's head immediately goes to, okay, this is an unlawful detainer. This is an eviction. And that was very true in the clerk's office. And my experience, especially in this case here, was that it was somewhat difficult to get this processed at the clerk's level simply because they weren't that familiar with it. And they just believed that what they should be issuing is a writ of restitution that flows from an unlawful detainer case. Amy.
Yes, there's a comment that says, because in Pierce County you can calendar and schedule a MSJ in 30 days, in King it can be months. And yes, and ejectment, you need a writ of assistance, and they may need a 5K bond.
Yes. And that is correct. When you do get your writ issued, the taking it to the sheriff puts you into a whole nother administrative process wherein they're going to require a bond. You have to indemnify the sheriff. Um, I think in this particular case, I had to wait until the new sheriff was took office because the timing of this was such that the bond that I received couldn't be issued in Ed Troyer's name. It had to be issued in Keith Swank's name. So there's a whole another level of just sort of administrative gyrations that needs to go on even after you've navigated, getting your summons and complaint filed and served. B, getting a judgment, whether that be a judgment on default or a summary judgment or perhaps a judgment after trial, then navigating the clerk's office to obtain the proper writ in the proper form that the sheriff will do something with. And then again, checking all the boxes that the civil unit in the Pierce County or whatever county you're dealing with, the civil unit of the sheriff's office. Again, they've got a very stringent set of requirements that you need to comply with in order for them to act upon this writ. And again, there's still another sort of bit of confusion that goes on there because the civil unit is just very accustomed to dealing with writs of restitution issued in unlawful detainer cases, and to see this other sort of writ come through, um, they scratched their head a little bit. Now, that's not to say that they pushed back, said, no, this isn't something that we can do. But it took a little explaining and a little, hey, this is what we're doing and it's different than that. And here's what the judge has ordered. Um, so it, curious if other practitioners have sort of taken this far. There was one comment about a writ of assistance and a bond. Um, does anyone else have any experiences with, say, Pierce County Sheriff's Office or any other law enforcement agency in getting a writ served and or a writ executed on?
I do have a comment. My role is on the government side, and I do work with police departments. And what I will tell you, I'm just going to put it in very plain terms. They are trained that if anything is weird or different, they are to call their legal advisor. And so, to the degree you feel like you are trying to get something unique or different served, it might behoove you to call the legal advisor so that they know that it's coming and they
Mhm.
can kind of pave the way. That we tell our officers all the time, don't try to play lawyer in the field. It's not your job to try and figure out what this thing is. Give us a call. And we get calls on everything from members of families trying to claim evidence for a deceased person, and we tell them you got to have the court order, right on up through things like this. So I would just say if you're doing something that's a little bit different, just put yourself in the shoes of that officer. You don't want them trying to sort it out.
Yeah, and you'll note that this writ of ejectment isn't a pattern form or a document that is generated by the clerk's office. And I think that may sort of further the questions that the civil unit may have. Be able to say, well, this isn't what we're used to seeing. What is this thing? Um, so again, I think that the comment or the advice to go up the chain is well taken. So some of this is subject matter that we've already touched on, but I think it is good to sort of zoom back out. Why do we do this stuff? What is the purpose of all of this? And with regard to quiet title, I think that these are sort of the four most common uses or sort of the primary purposes for bringing one of these actions, and that is a cloud on title. You are trying to convey a property, trying to refinance a property, trying to move a property into a trust, anything that may involve the engagement of a title company or title insurance. Um, any situation where a potential cloud is flagged and popped up. Certainly the worst time for this to happen is when you really are trying to close a sale and you've got a underwriter saying, no, I'm not going to be able to do this because you got this, easement from blah, blah, blah that is unresolved or something along those lines. But but it really in more commonly is comes down to, well, are there two people out there that are both claiming an interest in the same property? And that often will go back to whether or not a deed or a conveyance, or perhaps an easement or some other grant of an interest was valid. And I've seen these things, and I'm sure many of you have as well. I mean, a lot of these things that caused the disputes are things that happened a long, long time ago. Not in the 1800s or anything, but in the 40s or the 50s or even the 60s, and you see deeds and road agreements and parking lot agreements, easements, deeds from community property to separate property, and they sort of just lie there like a landmine, I guess, and they aren't a problem until they are one. My experience is that's going to be the most common use of a quiet title action, except for maybe the next one here, which is a boundary line dispute, um, which in my mind greatly overlaps with adverse possession claims, where both boundary line disputes and adverse possession claims often flow from, well, somebody put a fence somewhere or the driveway got moved, things that are geographic in nature and relate specifically to the physical um, features of the property. But a boundary line dispute may very well flow from some prior judgment, some prior conveyance, some previous boundary line or access dispute that was either unresolved or resolved in a manner that didn't really clarify where the new boundary line was or should be, or even sometimes it's just an inaccurate legal description. But these are all of the high level reasons that the people ultimately end up asking a court to quiet title. Any other thoughts from the people here as to other uses for quiet title, other experiences with quiet title, something that isn't mentioned on this list?
No difference in how you use it, Mark, but I will say that I, sometimes our clients, they are sent to us because they're involved in a sale or a transfer of the property, and they've gone to title, and they really are doing their best to explain to us as attorneys what the issues are. I generally call title and ask to speak directly with the legal department to make sure that I'm solving the issue that title wants solved,
Mm-hmm.
so that they can transfer this property, and I haven't solved the wrong problem and have to start over again at a later date. That's all.
I have experienced that same situation. Thinking recently of a commercial sale that I was involved with, and I was dealing with the buyer's broker who was telling me about X, Y, and Z that was the problem that Chicago Title was having. Um, And it wasn't really making great sense. And exactly as Stephen indicated, got a hold of somebody at Chicago Title, and they said, no, it is, A, B, and C, something completely different than what was being articulated by this broker. And again, I don't think that the broker necessarily did this intentionally. I think some of it, and probably Stephen's experience as well, is it's misunderstanding on the part of one of the parties. We get the game of telephone going on in a transaction where you've got, a real estate agent or a commercial broker. You've got somebody acting as a title or closing officer, and then you've got people in underwriting or actually issuing the title insurance, and all three of these people are communicating concepts through email or on the phone, and every time it goes from one camp to the next, there's a real tendency for things to get convoluted or misstated. So yeah, great advice. Go straight to the source. Talk to those people in title, whether it's the legal department or just a senior title officer, somebody who is actually looking at the title plant and knows how to read it and can tell you exactly, here's what the problem is. This is the conveyance that we're talking about. This is the problem with the legal description or whatever it is that's going on there.